Welcome back. So we are handling risks and due diligence. What is risks? You see, aside from human resources, goods, services, and a few others, blue chip companies thrive on two major fragile support systems. One is the reputation, and the other is the financial muscle. Reputation here includes, but not limited to, goodwill and brand perception, whereas asset-based, share capital, liquid cash, and other money's worth instruments constitutes to its financial power. So anything that can adversely impact on the brand's public image and its profitability is considered as a risk. A third item to add to our cards of risks is legal risks. Brands don't want anything that may drag them to court or expose them to sanctions due to defaults to comply with regulations or for any other kind of wrongdoing. That is to say, they usually prefer out-of-court settlement approach to disputes because litigation and other legal punitive measures affects the brand's reputation and consequently adversely affects the finances. So, this brings us to the question, what is risk? When we talk about risk, what do we mean by risk? What is risk? According to Merriam-Webster, risk is defined as possibility of loss or injury, and I agree. In other words, anything that negatively impacts you or your business is a risk. That leads us to the next question. How do we avert or manage risks in business? How do we forestall or avert risks from occurring in business? One of the measures that we take to avert risks is what we call due diligence. Taking note of due diligence or applying all due diligence processes. Putting strategy and systems in place to forestall risks, or even when risks arise, that they are well managed. See, but you have to be able to identify, evaluate, and prioritize possible risks. Once you have been able to successfully pre-identify and assess possible risks, the next step is to build up your defense system to mitigate or manage them. Regardless of the strategy you choose to adopt, it should indicate any or all of the following. These include the risk avoidance, risk reduction, risk sharing, or risk retention. So you retain this risk and you accept and you budget for it, or you share this risk, you outsource it, or you insure it, or you reduce this risk, you optimize and mitigate it, or you avoid it totally by eliminating, withdrawing from, or not becoming involved in things that can put you on harm's way. So do you know that these risks can be intertwined in themselves and not mutually exclusive? However, because of the immeasurable worth of reputation and the near impossibility of retrieving them when lost, leading brands do everything in their power to protect their name, even if it means losing all the monies. Hence, according to the Holy Book, a good name is better than riches. So, talking about risks here, we are talking about the kind of risks that brands shy away from. Definitely shy away from all kinds of risks, but when it comes to reputation, when it comes to their finance, when it comes to legal risks, they are very, very careful not to expose themselves to these things. So let's talk about these things in further details. For instance, legal risks. Legal risk can be partly construed to mean the risk of financial or reputational loss that can result from lack of awareness or misunderstanding of, or ambiguity in, or reckless indifference to, or the way law and regulation apply to our business. You see, it's relationship, processes, products, and services. This include but not limited to contract risks, regulatory risks, dispute risks, non-compliance risks, revocation of license risks, and so on. So there are steps you can take to protect yourself and business from legal risks. These steps are not in any way exhaustive, but a fraction of a robust risk management strategy checklist. And we're looking at things like pre-transaction due diligence, periodic legal audits, compliance with laws and terms of agreement, continuous legal education, especially as to your rights and the corresponding duties. Let's look at pre-transaction due diligence. When we talk about pre-transaction due diligence, what comes to mind? We'll get to a case study, but let's just look at this pre-transaction due diligence. Because we are in a world where most times nothing is as it seems, it necessitates the need to investigate and verify claims. Due diligence is an investigation, an assessment, a search or review performed to confirm the facts of a matter under consideration. In the business world, due diligence requires an examination of all claims before entering into a proposed transaction with another party. Carrying out due diligence exercise is not negotiable if we mean business and mitigating risks. Again, this is where you need the services of a lawyer or a professional accustomed to the field in question that you are investigating. Another thing that you must do to avoid risks is what we call periodic legal audits. You see, most people, including lawyers, go to sleep when they have fulfilled pre-transaction due diligence, but that's not where it ends. Where the real work starts is with periodic legal audits. This includes checking to ascertain that duties are being discharged as at when due, the rights are not being infringed, terms of agreement are being adhered to, processes are being complied with, and no introduction of encumbrances or vitiating factors. You see, you may also choose to audit your company by undertaking an analysis of current operations, strategies, assets, and legal infrastructure in place. It may also include reviews of documentation procedures as well as employee policies. Often, this type of audit is intended to analyze a company's legal needs as well as determine what those needs might be in the future. Likewise, it can be used to evaluate changes in legal requirements and new risks that may stem from changes in policies, or changes can be made to policies, objectives, or business structures. Let's talk about compliance with laws and terms of agreement. One of the ways to avoid risks is to comply. It pays to be compliant. You see, a great percentage of the troubles that businesses run into is as a result of non-compliance with laid out regulations or industry best practices. The same applies to contracts and other legal relationships. So except for frustration, which is an act of God like COVID-19, hardly will there be a breach of contract agreement if all the parties comply with the terms of the arrangement or of the agreement. So I will encourage you as a practitioner that understands business law to try and be compliant. And it's a mark of honor to be compliant. Another factor we have to bear in mind is continuous legal education, especially when it comes to your rights and your duties. You see, don't let law intimidate you. Even lawyers do not know all the laws. One of the brightest minds in the English legal system, by the name Lord Denham of blessed memory, is often quoted saying, "God forbid that a lawyer knows all the law, but a good lawyer is one that knows where to find the law." So you too should be able to find the laws on your area of business and areas of interest, and continually keep yourself abreast with the provision, especially as it relates to your rights and duties. Lawyers respect enlightened clients who know what they know, because ignorance can be expensive. In fact, ignorance in itself is a risk. So let's look at a case study. I would allow you to read through and you see the questions that follow. At your spare time, try to attend them, share your answers with me, and we'll be able to know if we're in the right track or what we can do differently, or get more ideas on how to approach the situation. But then the following question, I want you to identify risks. I want you to look at steps that can be taken to avert risks. Join me as we look at these questions. Over to your screen. Case study 1. So question 1 for case study 1. Question 1 says, identify all the possible risks that could arise from this transaction. Still under question 1, try and identify all the steps you should take as Mr. Bendover to avert risks. Case study 2, 2 months later. So number 1 question is, what will you advise TMO to look out for while reviewing a contract agreement? Take a look at the case study. So let's attempt some answers to, let's say, case study 2. So one of the things we have to advise him is to identify all the parties, making sure all terms are defined, including necessary signature blocks, identifying every referenced exhibit, schedules, etc., and making sure they are included. Double checking all mathematical formulations. These things are very important. TMO should review the contract documents while looking out to ensuring that the term expiration is explained, including instructions for early termination if applicable, identifying the rights of all the parties. In regards to the terms of the contract, checking that all of the performance obligations are accurate, verifying the accuracy of payment terms, clarifying any expenses that are reimbursable, and how to go about the reimbursement. TMO should look out as well to verify that the accuracy of warranties and representations, verifying for indemnification, checking to see if insurance is required or should be, checking for boilerplate provisions, agreeing to governing law and legal jurisdiction, verifying provisions for attorney fees. So that, in a nutshell, is some of the things that could aid you in your appraisal of the 2 case studies we have. Think through them, but let this be in your mind that when we talk about risks, sometimes it's unavoidable. Now, what companies do or integrate into their playbook is to develop strategy on how to manage risks if they arise and how to mitigate them. As a brand, you should pay attention to your reputation. You should try and avoid all forms of legal risks because litigation would impact adversely on your reputation as well as on your finances. Examine all the possible risks that are peculiar to your business. Consult your personal lawyer, attorney, and they would advise you on steps to put in place to mitigate, manage, avoid, or outsource those risks. So we see you again. The next topic will be dispute resolution, and I look forward to seeing you. Should you have questions, send me an email. Bye.